Smith.
Thank you, my Lord. So I was dealing with issues 1 to 4, and I was in the third topic that I was dealing with, which was fundamentally explaining why a reaching in argument is wrong, and I'm dealing with the authorities that have been relied on by the appellant and by the Air Centre. So I'm now going to turn to Commission and Parliament and Bartlett, but I hope I can take these fairly briefly. So these are dealt with in our written case at paragraphs 119 to 125 and in some detail, and we rely on all of those points. But just to take these cases at a headline level, and in my submission that's enough, if one stands back from the complexity about annexes and temporal effect of judgments and all of that, for today's purposes, a very simple point emerges from those cases, and it's this, that DLA mobility and DLA care were two separate benefits despite their common name. And as I've shown the court, that's because the legislation expressly says a person can be entitled to one component and not the other, and they each had, I haven't shown the court that, but the way it worked was they each had their own test. So, for example, the test, that the way that it would be worked out if a person could get DLA care would depend on satisfaction of various factors. And similarly, DLA mobility, how far you could you walk between 20 and 50 metres and so on. So they were effectively two separate benefits. And so what happens, and Mr Delamere explained the background to the Commission and Parliament litigation, what happened was that effectively everyone agreed that they could be treated differently. And then there's the complexity in the decisions about how that worked in terms of the annex, but effectively it was agreed that they were two separate benefits, and we say that that comes out from Commission and Parliament, and it also comes out from Bartlett. So they don't, those cases, our headline response is, they don't assist in this case where the facts are very different. The point about those cases is that everyone agreed they were two separate benefits, and to deal with the unusual issue which arose in that case, it was agreed that listing disability living allowance in the annex effectively covered both. But the background point for our purposes is that everyone was happy that they worked as two separate benefits.
But presumably the court still had to be satisfied that they were two separate benefits.
Yes, so let's then look at Commission and Parliament, which begins at page, because the court doesn't, I think, as Mr Delamere fairly accepts, I forget the word, parsimonious reasoning, I think he may have said. Was that right?
Lots of adjectives.
No bigger words for me, but sparse reasoning, I can understand that. So the Advocate General opinion in Commission and Parliament begins at 1793, and I won't repeat the history, but effectively there was a row about whether the whole thing could be annulled. So starting with, we don't know exactly what the court knew. We have to piece it together. But we can start in the Advocate General's opinion at paragraph, page 1797. So page 1797 is the listing. And then the Advocate General goes on to look at the national provisions in the UK, and that's on page 1800. And what you will see in the middle of page 1800, first column, is that there is a reference to the UK's legislation, and in particular, Section 1 of the Disability Living Allowance and Disability Working Allowance Act 1991 of 27th of June 1991. I had a look at that. That is an amending provision, and it amends some older legislation, but there is no material difference between that older legislation and what I showed the court in terms of a person being able to to claim one or both components. So having quoted the legislation, we then get the Advocate General saying, and this can only have come, we think, from the legislation, at paragraph 22, disability living allowance consists of two components, a care component and a mobility component. So that wording of component comes from the legislation. And then we see the agreement that the mobility component, as a special, the mobility component is an SNCB. So the argument really is, what about the care component? Can that also be an SNCB, or is it, as the Commission says it is, a sickness benefit? So that's the background. And Mr Delamere has explained that the slightly convoluted procedural background that led to all of this, but just tracking it through, we can see that in paragraph 17, the UK has taken issue with the whole thing being annulled because
17 of the judgment.
I'm so sorry, yes, 1834, paragraph 17 of the judgment. So there the UK says, well, we don't think the whole annex should be annulled because everybody agrees that the mobility component can be a special non-contributory benefit. Now, it follows from this, it's implicit in this, that everybody was accepting that the two benefits could be treated differently.
But the point that the other side make is they accept that because you have to look at each element of a benefit.
Yeah, yes, and the UK accepted it, and they don't accept it in this case because they were genuinely two components that could separately be claimed. So that's what the UK is saying. But as we've said in our written case, it's necessary to the UK's position that the UK was accepting that you could have this split. So it's our written case at paragraph 100 and it's a written case at paragraphs 121 and 122 that because everybody agreed that DLA mobility was properly to be characterised as an SNCB, this is paragraph 121 of our case, the only issue for the UK was whether care could be treated in the same way. And for that reason, it meant that categorising them differently was inevitable if the Commission was successful. So the UK didn't then argue that, the UK didn't argue, in fact, that the two components could not be categorised differently. So what the UK was saying is no care is also an SNCB, and that the court rejects. And then we deal at paragraph 122 with the legislation. And there really isn't a lot more illumination that comes from it. Paragraph 20, we see a reference to the Commission's pleadings because the UK was taking the admissibility point, but of course we don't know what they said. One can only imagine that they set out the legislation, and we know that the Advocate General had looked at the legislation. And then what...
So I mean, it looks from paragraph 17 as though the Advocate General says, notwithstanding that there are these two elements, one of which is an SNCB, one isn't, and because of that we're just going to put a line through the reference to DLA in Annex 10. Yes, and the UK complains and says we haven't had an opportunity to reply to that, and the court says, well, effectively, I think because the court accepts that it's all okay and it doesn't annul the whole thing, right, it doesn't then need to order the reopening of the oral procedure. I mean, what the court says at 20 is, look, the issue of the severability of DLA has been mentioned in the Commission's pleadings, but we don't know what those pleadings said. But that's what the court is saying, so go away, UK, you know, we're not going to say that this is inadmissible. But actually what happens is that the court accepts the UK's position in any event, because what the court rejects the idea that the care component is a sickness benefit, but it accepts that you could still preserve DLA mobility as an SNCB. So the reason why the care component could not be an SNCB was
what then?
That is addressed in the meat of the decision at so page 100 and 1842. So paragraph 52 on page 1842 captures the issue. Are the benefits at issue referred to special, having regard to the fact that their non-contributory nature is not in dispute? And that analysis is then at paragraphs 52 onwards. So the court addresses it in the run-up to paragraph 68 and 69, which is where it makes its reference to the DLA including a distinct part relating to mobility and the reference to the DLA component severable. Now, the court's obviously seen the Commission's pleadings because we've seen the reference at paragraph 20 where the Commission has referred to severability, but without those, we can't. It's difficult to say any more than that.
So is this right, that the SNCBs are a subset of coordinated benefits?
They are coordinated benefits, yes, although the Court of Justice has held that, we mentioned this in a case called Hossa, that if a benefit is a social security benefit under Article 3, it can't then be an SNCB. So that it's right to say, and I don't think anyone in this room would dispute, that there are certain complexities to do with the law relating to SNCBs. So far as this case is concerned, we say it's a red herring, and I'll come on to that, or I can deal with it now.
But just that the care component, that because it was a sickness benefit, it wasn't, or because it wasn't special, it was a sickness. Because it wasn't special, it was a sickness benefit, therefore it fell within 3, 1, whatever, and couldn't be a SNCB.
Yes, although there's quite detailed reasoning about why these benefits aren't special. So paragraph 53, for example, a benefit can be deemed to be special only if its purpose is solely that of specific protection for the disabled.
But what was it then? If it wasn't special, what was it?
It wasn't special, it was a sickness benefit.
It was a sickness benefit, and so it was coordinated fully rather than being in the annex.
And this particular judgment then led to a lot of litigation and a change in the UK's practice in relation to care, because until that point it had been treated as an SNCB. So the background is all very complicated. It doesn't, in my submission, other than, and I'll come on to Bartlett, other than supporting our point that what is an identifiable benefit, it certainly doesn't advance the case that you can reach in and pluck out the child amount here. And we say that both the upper tribunal and the Court of Appeal were right about that. I should just note that paragraph 56 of the judgment expressly confirms paragraphs 12 to 14 of Herx. And we've seen that De Kuyper also confirms those paragraphs.
Sorry, which paragraph?
Paragraph 56.
56.
Refers to Herx. Paragraphs 12 to 14, and De Kuyper does the same in one of the passages I showed the court. So moving then to Bartlett, we say that Bartlett supports the Secretary of State's case. Page 1654, the judgment begins, and the court will see that under 1408, Article 1T, there was a definition of benefits and pensions. Not terribly illuminating. It says benefits and pensions means all benefits and pensions, and then it says what that includes. So that's on 1654, paragraph 3. But it then says all benefits and pensions, including all elements thereof payable out of public funds. revalorisation increases and so on. But I show the court that because the court refers back to it in a passage I'm about to take the court to. Paragraph 19, the court captures the questions, page 1658. The National Tribunal asks whether Article 42A of 1408/71, and that's the old version of Article 3 of 883, should be interpreted as meaning that the mobility component of disability living allowance constitutes a special non-contributory cash benefit. So as Mr Delamere says, the upper tribunal refers to the court a question about the mobility component. And the court says this at paragraph 20, 1659, in order to answer those questions, it's first of all necessary to determine whether the mobility component of DLA can be regarded as a benefit on its own account within the meaning of Article 1T. And I say precisely the same here. Can the child amount be regarded as a benefit on its own account for the purposes of Article 3? So that there we have a clear statement that it needs to be a benefit on its own account. And then in paragraph 21, it must be borne in mind in relation to that question that the mobility component is severable, with the result that that component alone could be included on the list in Annex 2A if the UK decided to create an allowance which concerned that component alone. So that's dealing with the listing bit. But then this, it follows that the mobility component of DLA by itself constitutes a benefit. And we say, in this case, the child amount by itself does not constitute a benefit.
Sorry, where is that last
Paragraphs
question?
19 and 20 and 21, the final sentence
Yes.
of 21, it
Thank you.
follows
Yes.
that.
Yes.
And then just to note again that at paragraph 32, the court repeats that disability living allowance, this is the final 3 lines of paragraph 32 on page 1660, disability living allowance has always had 2 components clearly identified in the national legislation at issue in the main proceedings, which is a person can be entitled to one or the other. So that's, in that sense, to say that they're severable simply means that they're already 2 discrete components that can separately be claimed. So the fact that...
But there was the further question they wanted to know the answer to in Bartlett. Given what the court had said in the Commission and Parliament, does that mean that the reference in the annex to DLA
Yes.
now needs to be read as just referring to the mobility component?
Yes. So what the court is saying in that paragraph specifically is it's not the case that the mobility component can't be regarded as listed in Annex 2A because it's not there separately. And then it says because it's always had 2 components. But it's important, just that also informs, we know that the court knows that when it's saying is it a benefit on its own account, I mean,
in effect, it's reading the entry in the annex which says DLA or equivalent long. It's reading it DLA, i.e. mobility allowance and care allowance.
Yes.
And then it says one bit is outside varies in terms of including it with the annex, so that
Yes.
gets penciled out, but the other one's still there and is still perfectly permissible.
Yes.
I mean, it's a way of reading the annex that seems different from the Advocate General in, is it Commission and Parliament?
Yes, and
Yes.
and it...
Because
yes.
he seemed to think that it's all bundled up together. Therefore, if
Yes.
one bit is to be struck out, but everything needs to be struck out, but they say read it long and you only
Yes.
strike out one bit.
And that's...
So you don't have to wait, so the UK doesn't have to wait until it's got round to amending the annex
Yes.
in order for
Yes.
the different rules for SNCBs to apply to the mobility component.
Yes, and that's right, and that's how it continued after the judgment of the Commission and Parliament.
I mean, it is a slight shift from what was said in Commission and Parliament, because there they seem to be leaving it to the section of the judgment on temporal effect, in effect saying, well, the UK can have a second bite of the cherry, but here
Yes.
they've reached the conclusion, actually, you don't need to.
Yes, all fine. Yes. And for our purposes, the interesting part, there are two interesting parts to the whole saga. The first is that everyone accepted that they were two discrete components, and second, Bartlett has to be a benefit in its own right. And the reason that it was accepted that they were, in effect, benefits in their own right was because despite the common name, a person could be entitled to one and not the other. And we say that is very much not the position for universal credit for all the reasons I've given. So, rounding up, we essentially say that nothing in any of the authorities that the court has been shown establishes that the court can ignore the fact that there is no benefit in domestic law, which is the child amount. There is no payment under domestic law, which is the child amount to which a person has a discrete entitlement. There is nothing in any of these authorities to establish what we say is a radical proposition that the structure of the domestic benefit, its condition, its purposes, and so on can be ignored. So that was really the third part of my submissions, to answer the cases that are relied on. Very, very slim pickings, which is a phrase the Court of Appeal used in another court. I think the Court of Appeal said anything in the cases is mirages rather than anything actual. We say there's simply no support for what needs to be established.
I think slim pickings referred to CG.
It did, and I'm going to come on to that, yes, because I agree. It was very slim pickings.
I mean, just on the Bartlett analysis, it's not actually a principle of severability at all.
No.
It's just if you treat the entry to DLA as read long, as two things, you strike out one. There's just one bit, one part of the benefit has been taken out, leaving the other one there. Yes,
and the other point, of course, is the court isn't doing anything to domestic legislation. They're already two discrete components identifying. So it's not active severance of any kind by the court in Commission and Parliament. It's simply reflecting what the domestic legislation does, and that rather proves the Secretary of State's point that one has to start with the domestic legislation and indeed end with the domestic legislation, because the whole point in Commission and Parliament and Bartlett is they were already two discrete components. So it's not, there's no active reaching in, deconstructing, excision, anything like that. It's just that's how it was under domestic law. So in that sense, it supports what the Secretary of State is saying. So just then on issues 1 to 4 to deal with my mop-up points, can I start with the slim pickings and the Advocate General's equivocal footnote? We rely on everything that is said in the Court of Appeal's decision at paragraph 51 about this.
So are you dealing with CG now?
Dealing with CG.
I'm not sure whether it's still relied on, actually. It's not in the appellant's written case, I don't think. And
I think
it is in the written case.
Yes, I think.
No, it was just the footnote. Yes.
Yeah, the footnote.
Yes.
Yes. So I'll deal with it very briefly. Now, the first thing to say, I was in CG. There wasn't any argument whatsoever about this. None. Had it ever been flagged that there was a suggestion that bits could be plucked out of universal credit and treated as discrete benefits, I can assure the court that we would have had quite a lot to say about that. So I don't know, we don't know why the Advocate General saw fit to make that comment. He may just have been pondering, he may just have put it in, we don't know. Mr Delamere said that he described him as having grappled with the point. We say that seriously overstates that footnote. All he said is, he didn't even say will be, he used the words may be in his footnote.
Can you just remind us the reference?
Yes, so the bit in the Advocate General's opinion is at
1746 is the footnote.
1746. Thank you. So it's footnote 19. As to what the expression universal credit covers, it serves to designate a variety of allowances, and then he says some of which may be governed by special rules of EU law. It doesn't even say what the special rules of EU law are, but he says maybe. So, as I say, it's simply not what the case of CG was about. We don't know why the Advocate General said it, but it's certainly not picked up by the court in any way, shape or form. So it really is slim pickings.
So I continue to think of so he's referring back to point 25 in his opinion, which is page 1729. I continue to think it's a slightly problematic way of describing the objective of universal credit, because he says the objective is to replace things rather than looking at it on its own terms and saying, well, here's a benefit, what's its objective?
Precisely, yes, that's the incorrect approach.
But as I understood it, it was relied on to suggest that there is a lack of clarity in this, that is sort of relevant to whether we should make a reference point, but you're going to come on to that.
Yes, we say, having everything that I've shown the court, there really isn't a lack of clarity. It's something which appears to come out of the blue in his opinion. As I say, there was no argument about it. I don't think anyone's suggesting the Advocate General had some special knowledge so that he could comment on this without being directed to any authority on the point. There were enough difficult issues in this case as it was. So certainly we would say that there is no uncertainty. The position is very clear for the reasons that I've been submitting.
And just out of interest, do we, now looking at the footnote again, page 1746, do we have European Commission and UK in our bundle?
That's the case that I took the court to earlier.
Oh, that's that one.
That's
okay.
that one.
Okay, yeah.
So again, as I showed the court, that case isn't really even about that. It was about something different when one looks at the issues, and it was accepted in that case that CTC was a family benefit.
Yes, thank you.
So that's all I have to say about CG. Two other points that have been made. First of all, the spectre of SNCBs.
Sorry,
the spectre of SNCBs, and I have to say, we don't entirely understand the argument that's being made here. Paragraph 132 of the appellant's case, which is at page 126.
Sorry, paragraph?
Paragraph 132 at page 126. And certainly I think it's fair to say that this whole issue did not really feature particularly in the Court of Appeal, but paragraph 132 says, neither can the UK escape its legal obligations by saying they're difficult to comply with. To be clear, that's not our case. The UK government chose to subject UC to the full coordination regulation by failing to list it in Annex 10 as an SNCB. So we had understood that to be an argument that the UK should have, in the annex, put universal credit.
Yeah. You couldn't.
But we couldn't.
We put the child element of universal credit.
But, yes, but can I come on to that? We didn't list universal credit because it's not supplementary, substitute or ancillary cover, and it's not covering one of the Article 3 risks. It's not a social security benefit at all. We didn't list child amount as an SNCB because it's not a benefit on our case. So the Secretary of State says this isn't a benefit. So the Secretary of State says it's a calculation factor. The Secretary of State couldn't coherently have gone to the Administrative Commission and said let's list the child amount, or indeed any other amount.
Of course, it would have been contrary to your case. Yes. But I think what they're saying is, if insofar as you're saying the heavens will fall in if we decide this against you, the heavens may be propped up again if you include it in Annex 10 or some element of it in Annex 10.
Yes, well, that would depend on...
It's a calculated... What they're saying is you took a calculated risk by not putting it in Annex 10 that you might lose, and then it's this, and then it's not in Annex 10 to help you.
I think it wouldn't be unfair to say that the UK's position was simply that I'm not sure it even occurred to anybody that it should have been put, because it's not a benefit. But I can't speak for that. But that's our short answer to the point. So really all of this stuff about SNCBs, which is all very complicated, doesn't help here. Either we're wrong or we're right. Then, just again to deal briefly with the points that have been made about child tax credit, we accept, of course, and it's hardly surprising that when creating the new benefit that was universal credit, that the government drew on features of older benefits, including CTC. But the short answer now is that that's in the past, and to pick up a point that my Lord Sales made in relation to the Advocate General, the UK has now designed a different benefit, genuinely so, for the reasons I showed the court in the white paper. It was intended to revolutionise the benefit system. So the question is whether that new benefit is a social security benefit, and it isn't. And then the question is, can you pluck a bit out of it that isn't a benefit and treat it as such? And the answer is no, you can't. There isn't any authority for the proposition that you can reach in and extract a calculation factor simply because of the history. And indeed, we submit that would be wrong in principle, because it would mean that in designing new benefits, the member state would have to think, well, we better design this with the coordination system in mind, because we've got to make it fit within the coordination system. So that's our answer to that. For completeness, we've addressed specifics in the annex to our written case, but that is our answer. And we say nothing in SC, this court's decision in SC helps, for the reasons I've just given, and also because, as my Lord Sales pointed out yesterday, that's a case about human rights. And then finally, can I just deal briefly with what we say the consequences of all of this are? They're set out in paragraphs 72 to 77 of our written case. And I'm not going to get into this in detail because the court will have heard, as I've been going along, making various points about difficulties that may arise. Can I just deal with a couple of points that are made? The first is, what's the problem? You've already got the ability to coordinate benefits and liaise with other states. Yes, absolutely we do have that as a government, but that's not the point. The point is that universal credit hasn't been designed in that way. And so in the context of universal credit, the claim form doesn't ask questions that would be relevant, for example, to applicable law and competence. We don't have procedures in the context of universal credit to liaise with other states. There is no basis in universal credit for working out, in all the different situations where this might arise, how the legislation would work. So it doesn't matter that we have the ability. Of course we do. We're still coordinating social security benefits now. That's not the point. It's not the hand-wringing that it's been represented to be. This is the genuine concern of those with responsibility for administering this system. And I mentioned earlier when I was opening that while this claimant might have an advantage from the child amount being treated as a benefit, others would not. And there's a concrete example given in paragraph 34 of the Court of Appeal's judgment. So the example given there is that, this is at page 219 of the bundle. If there were a claimant living in the UK with their child, so their child is actually here, but with a partner living and working in the EU, the way that Articles 67 and 68 work would mean that the UK, that the other EU state would be responsible for family benefits, and the UK could say, we are not competent to pay you, and all that the UK would then have to pay would be a supplement. So people in this situation with children actually living here would lose money. Take the example of a claimant living in the UK now with their child getting universal credit, French husband working in France. At the moment, the child living here and their parent would get the child amount. If the child amount is a family benefit, then the UK can say, well, France is responsible for family benefit, and all we're responsible for is a supplement in circumstances where a supplement is payable, which it isn't always. So suppose that in France, the family benefit is I'm taking hypothetical figures now, but suppose in France the family benefit is £400 and say the child amount is £300, that person gets nothing because the French benefit is bigger. Supposing the French benefit is £200 and the child amount is £300, the person gets £100, whereas now they're getting £300. I'm going to turn my back to check I've got that correct. That's correct. So it isn't something that is universally going to work in people's favour. And I should add, of course, if other allowances are also discrete benefits, other amounts within universal credit are also now to be coordinated as we haven't begun to think about how others might be disadvantaged because of the impact of the rules in Title III. But to take an example, there are quite specific rules for people getting sickness benefits from another state. They might be affected. So it really is.
I think the point you're making is just a function of what the coordination regulation does, because it assigns responsibility, if you're within a benefit, it assigns responsibility between different member states to have prime responsibility for providing a benefit. And then, in effect, from a claimant perspective, it's a matter of good luck or ill luck.
Exactly.
Whether they're better. Sorry, just to make the point, whether they're it's more generous to have this benefit dealt with in France or not.
Yes.
So just giving the example, how does France know whether we treat the child amount as a separate benefit or not?
Well,
so, because presumably, well, I would have thought that in your first example where the child is living here, the French husband is working in France, at the moment the mother here, let's assume, gets the child amount, you said, right? But does that mean that then the French husband doesn't get the child amount?
No,
or doesn't get whatever is payable in...
No, he gets... So what happens in that situation is because the child amount is not a family benefit, nobody cares. France doesn't care. France... What happens now is because of the way Articles 67 and 68 work, France has primary responsibility for family benefits. So France pays their family benefit, and that's what France does. And at the same time, universal credit, because it's not a social security benefit, nobody's interested in what's going on in France with family benefits. What DWP doesn't do if someone comes along and says, I'd like universal credit, is say, aha, but are you getting a family benefit? Is someone else in your family getting a family benefit? It's not relevant because it's not a family benefit. If it were a family benefit, then it would be relevant to ask those kinds of questions.
Yeah, I mean, in effect, it's hypothesized because it's the way the system works.
Exactly. And so the reason that we make these points, we're not suggesting that it's really hard, so don't find in our favour. What we're saying is this illustrates that this regulation is ill-suited to deal with universal credit, that the child amount is not a benefit and cannot be coordinated as such. And these consequences illustrate that effectively what's being done is upsetting the system of coordination. And it illustrates, as the Court of Appeal said and the upper tribunal said at paragraph 48, that what you're really doing is trying to create a new self-standing benefit and rewrite history. And just to deal with one final point, which was to do with the letters in this particular case and the decisions that have been sent, we don't object to the court seeing those. We just say they don't help. What happened here is, regrettably, there were errors in recording that Ms Simkova had a child living with her, and that led to amounts being added into a report that shouldn't have been. And so as a result, the department says there's been an overpayment, but none of that affects the points that I've just been making.
Well, it affects Ms Simkova suddenly to get a letter out of the blue saying she owes thousands of pounds.
Understood, and that ought not to have occurred. It's being looked at internally, and I think we've said that in our written case. It obviously is subject as well to what happens in these proceedings. So, yes, that's right. What I say, though, is in terms of the issues in this case, it doesn't assist. But I entirely hear, and my clients are sitting here and well aware of what your ladyship says. Can I just turn my back for a moment?
Yes, of course.
Yes, so that's, unless the court's got any more questions for me on issues 1 to 4, that's all I have to say about that. And I was proposing to move to the reference issue.
Yes, thank
And
you.
I now become Sir James. So we make 2 core points on the reference issue. 1, we say there's no ability to refer because in this particular case there is no issue about interpretation of the withdrawal agreement, and I'll explain why in a moment. And second, we say that the power to refer isn't engaged because proceedings were commenced before the end of the transition period.
And can I just check on your first one? There's no issue about the interpretation of the withdrawal agreement. I think you've said at another point that in an appropriate case, you say not this one, questions about the interpretation of Regulation 883 would be
Yes.
a matter of interpretation of the withdrawal agreement. So you're not trying to draw some
No.
distinction between what's in the withdrawal agreement and then what's in the whole acquis of...
No, we're not. Your Lordship's absolutely right. The reason that we say that this isn't about interpretation of the withdrawal agreement is because as at the date of the decision, which was October 2019, the relevant bits of the withdrawal agreement weren't in force. So we say there simply can't be an issue about interpretation of provisions which aren't in force as at the material time. So to flesh that out, could we begin by looking at what is an issue in this appeal? And we address that at paragraphs 136 and 137 of our case, which is at page 179. So I've already shown the court section 12.8b. We note at paragraph 136, and I said this earlier, that one of the circumstances to which section 12.8b refers is the law. And we've cited there the case of Riley, which accepts or proceeds on the basis, I don't need the court to turn it up, but it proceeds on the basis that that is how it works, subject to explicitly retrospective legislation. Riley is quite a complicated case because it was, Your Lordship's smiling, I think Your Lordship may be familiar with it because it came to this court, went back down to the tribunal, went back up to the Court of Appeal, and the issue about section 12.8b wasn't a huge feature in the case. The Court of Appeal, shall I show the court Riley?
Yes, I think we all think this is an important point.
Yes. So Riley is at page 1198. The relevant paragraph that we've cited is at 1198. Sorry, the background, and it's complicated, is in the head note, which begins at page 1138. So it's all about sanctions. So the claimants in the first case had JSA, and I'm reading from the head note. They were required to participate in certain schemes, and if somebody didn't participate, they could be sanctioned. they brought judicial review proceedings establishing that the 2011 regulations were ultra vires. And won in the Court of Appeal in establishing that those regulations were ultra vires. And then the second claimant brought a successful statutory appeal in the first tier tribunal in respect of 3 sanctions withdrawing his JSA. And the Secretary of State, while his respective appeals were pending against the first decision to the Supreme Court and to the second one to the upper tribunal, enacted the Job Seekers Back to Work Schemes Act 2013, which retrospectively validated the 2011 regulations. That was then the subject of, I said this was complicated, that was then the subject of a separate judicial review claim challenging the decision to promote that act. But before that claim could be heard, this court then held in the first claim that the 2011 regulations were ultra vires.
Sorry, can you give me that last bit again?
Yes, so before the claim could be heard against the 2013 Act, the Supreme Court held that the 2011 regulations were ultra vires.
So that retrospective act was needed then, effectively?
Yes, so that comes next because that's this decision of the Court of Appeal. So this is the complicated backdrop.
Right.
Then...
So is this Court of Appeal decision in the judicial review proceedings challenging the
2013 Act, yes, because the judge allowed the second claim, which is the claim about the decision to promote the 2013 Act, on the grounds that it had the effect of determining the litigation in the Secretary of State's favour, and that was contrary to Article 6.
Right.
Then there was further litigation in the upper tribunal, which said that the 2013 Act could be read down so as to have no effect in the claimant's cases, and that was then heard by a 3-judge panel, and it's that appeal that ends up in this court. Now, in the course of all of the very complicated arguments that were going on in that case, it was an argument was made about the effect of Section 12.8b. So that argument is captured in paragraph 136 at page 1197.
Paragraph?
Paragraph 136, page 1197. So the argument that was being made is that because of the effect of Section 12.8b and its focus on the law as in force as at the date of the decision, this is between G and H. Mr Jones submitted that that meant when the FTT came to consider any of the appeals pending as at the date of the coming into force of the 2013 Act, it would be obliged to disregard the effect of the Act, notwithstanding that it was expressed to be retrospective, because its enactment would constitute a circumstance not obtaining when the decision appealed against was made. And that argument is rejected. And it's being made as a construction point. And the Court of Appeal is essentially proceeding on the basis that Section 12.8b does require the law to be the law as it is at the date of the decision, but it says the effect of it can't be to nullify subsequent explicitly retrospective legislation which would otherwise govern the decision of the first tier tribunal.
But is that the authority you rely on to say that the circumstances referred to in Section 12.8b include the law at the time? Because that seems to be building on that.
It is. It may be that it would be helpful to have shown the court the upper tribunal's decision. We can do that, and we'll obviously check that others are content, but the upper tribunal deals with it in a little more detail.
Sorry, in our case? Or,
no, sorry, in Riley.
So, I mean, I'm very slightly surprised that there isn't more jurisprudence about this, because it's quite a basic point. It must have arisen before. It
is surprising. We have looked. There's a lot of case law about how it works in terms of what about if somebody produces evidence about something that's happened later. So some members of the court may have come across the book, those books. There are 5 volumes of them and they deal in detail with social security legislation. There is commentary in that book, but it's effectively dealing with the point that I've just mentioned. Right. So this is what we have.
But was there any argument in Riley as to whether circumstances included the law at the time, or was it just accepted? Well, even if it does, this is explicitly retrospective.
Certainly, so far as I can tell from the Court of Appeal decision, it was accepted. I believe, and I'm
reading 137, I think it's fair to say it seems to be the premise on which they're working, that you need some subsequent explicitly retrospective legislation before you step outside that framework.
Yes.
I mean, well, it's ambiguous in a way, isn't it? It's ambiguous in a way. It could be just, well, whatever it does, it doesn't nullify subsequent explicitly retrospective legislation.
What I can say from looking at the upper tribunal decision is in writing, at one stage, the Secretary of State argued that it only meant factual circumstances and not changes in the law, and the upper tribunal said that argument is not sustainable. So
that's the upper tribunal.
That was the upper tribunal. Yes, exactly. But I have to say I would need to go back, I think, and read in more detail to make sure I was providing the court with everything that it would need to know about the upper tribunal decision. We can certainly provide that to the court, but effectively
I think it would be helpful.
Yes, absolutely.
That sounds like it's dealing with it positively, whereas, as my lord says, we're left with an inference from this slightly ambiguous paragraph.
Yes, and I apologise for not including that. So we would say, though, that even if one sets aside section 12.8b, in any event, on any ordinary analysis, what is the court looking at when it's dealing with an appeal from the tribunal against a decision which was made in October 2019? It would look at the law in force as at the date of the decision, and we say that that theme underpins the judgments in Lipton. So where does that get us? This is a decision made.
Lipton was different because that was just the one-off cancellation of the flight.
Yes, accepted.
Whereas here the decision creates an entitlement which, as Mr. de la Mare explains, spans the whole 3 different phases.
But that's we come back to my point but if somebody won the lottery, that wouldn't be relevant. It would be relevant later. So what the court's looking at, for example, supposing in October 2019, it's not a great example because it relies on the law point, but if I'm right about the law, the fact that the law changes in 2022 can't help somebody to establish an entitlement in 2019, and logically that makes sense as a proposition. Supposing social security law provides that in 2019 a person is only entitled if they meet condition A, and somebody appeals, and they appeal on the basis that says, well, in 2022 you changed it so that I only had to meet condition B. We would submit that just as a matter of ordinary legal analysis, the answer must be that they can't benefit from something that happened in 2022 unless it's retrospective. Because one's looking
is this linked in with your point that actually to get universal credit you have to make a claim?
The thing about social security is that you're looking at entitlement as at the date of the decision, and that I think there is no controversy that section 12.8b does that. So as I said, my lottery example earlier, what one's looking at is the person's circumstances as at October 2019, because for any given period you have to be entitled in that period, and universal credit is assessed monthly. But for social security, whether or not you're entitled in October 2019 is an entirely separate question from whether or not you're entitled in 2022, in the sense that you're not entitled in 2019 because you happen to be entitled in 2022. You've got to look at what's happening in 2019 because social security legislation is based on meeting of conditions on any given date.
So do you say as a result of that, that this case is governed by Section 6 of the 2018 Act?
Yes.
There is no question no question to be referred within the ambit of the withdrawal agreement as implemented by the amendments to the 2018 Act?
Yes.
And within Section 6?
Well, I don't say Section... I accept that if Mr de Mayor is right and there is a power to refer in Article 158, I accept that that would then trump anything in Section 6. But I say there isn't anything to the contrary in Article 158 that trumps Section 6.
But it would only trump it in respect of a matter within the ambit of, of Article 158 as implemented.
Yes, so it doesn't trump it in this case because Article 158 isn't engaged in this case.
So I think that's what my law was putting to you. In your case, we're not concerned with interpretation of the Withdrawal Act, just concerned with the operation of the law in 2019.
Yes.
And what was being put to you was, is the logic of your case that Section 6 of the Withdrawal Act 2018 then applies, which says that we may not refer?
Yes.
And you're saying that?
Yes, I am. So we say that what we're dealing with is retained EU law. There is a wrinkle that we've pointed out in our case, which is in paragraph 140, and that wrinkle is that 883/2004 was revoked as retained EU law by the statutory instrument referred there.
Sorry, referred to paragraph?
It's paragraph 140.
Of your case.
But we say that that doesn't stop the Lipton analysis from applying insofar as it applies to the appellant's accrued cause of action, i.e. this appeal. So in other words, what that regulation does is stop 883 biting as retained EU law for periods after the 1st of January 2021. So the court will know that what the 2018 Act does in substance is bring EU law into the statute book as retained EU law, and under the analysis in Lipton, it does so for two purposes: accrued causes of action and going forward. What that SI does, we say, is it stops 883 being retained EU law going forward. So on the 2nd of January 2021, somebody who doesn't benefit from the withdrawal agreement can't say, aha, but I can rely on 883 as retained EU law. What it doesn't do, we say, is stop 883/2004 being retained EU law in respect of an accrued cause of action.
Which you say you have, because you have the...
Exactly.
You ought to have... yes, which, sorry, Ms Simkova would have on this part of the argument,
yes,
because she's saying, I ought to have won my appeal.
Yes.
About a decision that happened in October 2019. So that's the reason for the analysis.
So in effect, as soon as on her argument, the wrong decision is made on the 17th of October 2019, and at least from the time she brings an appeal against that, she has effectively an accrued right.
Exactly, yes.
To have that corrected.
Exactly.
Right.
But then there is this oddity, which the Ms Simkova points out, that the FTT could have made a reference in 2019 under Article 267, but once it moves up the judicial ladder, that ability disappears.
But we say that's simply a consequence of a line being drawn in relation to the winding down of the CJEU's jurisdiction, and that's where the line was chosen to be drawn. So can I unpack that?
Yeah. Can I just see how that fits with what you were saying about the applicability of Section 6 of the Withdrawal Act?
Yes.
Because I would have thought it's not so much that it's as you move up through the judicial system that you lose the right of reference, it's that the line in Section 6 of the Withdrawal Act comes down, and we're now just in the world after that line has come down.
It's the time it takes for it to go up.
Which means that we've gone past that.
Exactly. So can I show the court the withdrawal agreement?
Before you move to that, could I just ask this? You say the effect of the legislation here is that 883/2004 no longer applies as what we now call assimilated EU law, but it does, of course, continue to apply to the United Kingdom and domestically within the United Kingdom by virtue of the withdrawal agreement.
Yes, after the first. Yes, that's absolutely right. So the reason that it's revoked as retained EU law for periods after the end of the transition period, which is from 11 p.m. to be precise on the 31st of December 2020, is so that some people will be able to rely on the withdrawal agreement, but what that regulation stops from happening is somebody who can't rely on the withdrawal agreement to say, but you've also preserved it as retained EU law. So on the 2nd of January 2021, I am going to rely on 883/2004 as retained EU law.
And presumably someone, not Ms Simkova, but someone in her position facing the same problem now could ask for a decision by the Secretary of State now.
Yes.
And that would be under the withdrawal agreement, because you concede the interpretation of the withdrawal agreement includes interpretation of everything that's brought in via whatever is the relevant title of the withdrawal agreement. And so if there was a claim now by someone in that position, Article 158 would be potentially available.
Provided they were within scope of the withdrawal agreement, but yes.
Yeah, but they would, I mean, on what we're talking about, they would be within.
No, I accept that. But it's not where the withdrawal agreement draws the line. The withdrawal agreement does not do what the withdrawal agreement did in the SkyKit case, which is to make specific provision for pre-existing courses of action. Right. So in the language, we refer to that in paragraph 147 of our case. So the language that this court was considering in SkyKit was in Article 67 of the withdrawal agreement. We don't have it in the bundle, I don't think, but it referred to legal proceedings instituted before the end of the transition period. And the court,
sorry, which article of the withdrawal agreement?
67 in SkyKit. Oh, right. It's in 147 of our case, and the court will see that's different from the language that's used in Article 158.
So can I be here? Are we now moving to your second argument?
We are. We're moving to the withdrawal agreement. So we're dealing with no power to refer under the withdrawal agreement.
So you finished your first argument, is that right?
Yes.
Yeah. Okay, I just wanted to be clear.
Yes.
So you're coming to the temporal argument?
Yes. Yeah. Yes. So
the second temporal argument in a way, but anyway.
So complicated. So turning up then the withdrawal agreement, which is on page 756. No, that's the wrong bundle. So I just wanted to show the court briefly some of others of the recitals. So page 756, and apologies for the small text, there is a reference in the first recital to the UK's sovereign decision to leave the EU. And there is a reference in the fourth recital to the law of the EU and of Euratom in its entirety ceasing to apply to the UK from the date of entry into force of this agreement. Against that background, the objective is to ensure an orderly withdrawal of the UK. And then it says, necessary to provide reciprocal protection for EU citizens and for UK nationals. That's effectively it's foreshadowing what ends up in Title 2 of the withdrawal agreement. Sorry, Part 2, not Title 2. And then again, at the top of the next page, there's another reference to an orderly withdrawal. So, unsurprisingly, the withdrawal agreement thinks that legal certainty, and there's a reference to that in that top recital, legal certainty to citizens and economic operators, as well as to judicial and administrative authorities, is a good thing.
I'm so sorry, where was the reference to legal certainty?
It's at the top of page 757 in that recital, second line.
Yes, second line.
Oh, yes, got it. Thanks.
Now, the court was shown yesterday the Social Security Coordination Rules are in Title 3. So the way that the withdrawal agreement is structured, as Mr Delamere said, is Part 1 common provisions, which include scope provisions, and then Part 2 and then Part 2 on page 761 deals with citizens' rights. And there are 4 titles in Title 1, general provisions in Title 1. Title 2 deals with rights and obligations. There's already been a fair amount of case law on those provisions, although none that has reached this court yet. Title 3, dealing with coordination of social security systems, and Mr Delamere has taken you to those. So, and Title 4, finally, other provisions. So the rights are in Part 2. Can I then ask the court to turn to page 786, which is Article 185, which is about entry into force and application.
Did you say Part 5 or Title?
It's page... Which part it's in? It's page 786, and it's in Part 6, institutional and final provision. So Part 6 begins on page... No, I'm sorry, actually, I'm not sure. We're missing pages. So I can't remember off the top of my head whether Article 185 is also in Part 6. I think it may be. Yes, it is.
I think it is.
Yes, that would make sense because it's institutional and final provisions.
Yes,
so.
okay, thank you.
So Article 185 on page 786, the court will see down towards the bottom of 786 there are various indented passages, indented paragraphs, and above that a reference to the protocol, and then directly above that there's a reference to parts 2 and 3 with certain exceptions that are not material here, applying as from the end of the transition period. So that's why we say that Title 3, which deals with social security coordination, isn't in force as at the date of the decision in this case.
That's because it's part of Part 2, is that right?
It's part of Part 2. Yes, so Part 2 is those 4 titles.
And the end of the transition period was 31st December 2020?
Yes. So then, if we go back to Article 158, we make 2 simple points. So the first is whether this case raises a question concerning the interpretation of Part 2 of this agreement. And as I said yesterday, our position is that given that it concerns a decision made in October 2019, it cannot be raising a question about the interpretation of Part 2 because Part 2 wasn't in force as at the date the decision was made. The second point we make is the point that the power to refer is contingent on there being a case commenced at first instance within 8 years from the end of the transition period. So not...
Sorry, could you just repeat that?
Yes.
I didn't catch the beginning of the sentence.
Article 1581, the second point we make is the power to refer is contingent on there being a case which commenced at first instance within 8 years from the end of the transition period. So not the sort of language in Skykick, but that it has to be within 8 years from the end of the transition period. In other words, the case will be commenced after the end of the transition period. And that's the point that my Lord Richards was making yesterday in the course of oral argument.
So you read it as meaning it must be commenced at first instance between the end of the transition period and 8 years from the end of the transition period.
Yes, so starting after the end of the transition period, and then there's another 8 years. And we contrast that with the language in it's Article 67, which was considered in Skykick, again at paragraph 147 of our case, where the withdrawal agreement uses the words in respect of legal proceedings instituted before the end of the transition period, and we contrast that with the wording used here.
I think in Lipton there were other instances of savings for proceedings already in existence in relation to general principles or the charter or something.
Certainly under the 2018 Act, that's
yes.
right, yes. But for withdrawal agreement cases...
Yes.
Yeah, so I think the point you're making on Article 67 referred to in Skykick is that's within the withdrawal agreement itself. So
exactly.
It makes the drafting of 158 look deliberate.
Yes, that's right. And we say it is deliberate because this temporal limit makes sense because the provisions don't come into force until after the end of the transition period. And so it makes sense that there shouldn't be a power to refer in circumstances where the provisions aren't in force. Now, Mr. Delamere says, well, that's a donut. We say it's just where the contracting parties to the withdrawal agreement have drawn the line. We know because it tells us that the UK has left the EU. We know because it tells us that EU law no longer applies. So a decision has been made to wind down the CJEU's jurisdiction in cases about EU law, and only to set a new right to refer once the new provisions come into force. And that's the decision, that's where the line was drawn. The contracting parties could have made a special carve-out for proceedings instituted before the end of the transition period, but they didn't.
I mean, I suppose if you're looking at it from the point of view of the withdrawal agreement, it's not a donut because the rights only come into force from the end of the transition period, and you can bring a claim from the end of the transition period.
Exactly, so it makes sense. Yes, and it is the consequence of the UK having left that there is a cut-off. So what was decided was when issues arise about the withdrawal agreement, even if it's EU law as applied by the withdrawal agreement, then there can be a limited, for 8 years, ability to refer, but in respect of older cases, it stops at the end of the transition period.
So you could make a reference to up to the end of the transition period under the original, under the Treaty of Functioning of the European Union, actually.
Yes. And then as a
and then instantaneously that would be succeeded by a new power,
yes,
provided that the subject matter of the reference related to the subject was within the ambit of the withdrawal agreement.
Exactly.
Yes.
So that's what we say about the reference issue. To the extent that there is a power to refer, we say that the court, and it's a discretion now, so we say that that change of language is deliberate, and we deal with that in paragraph 150 of our case. Everybody knew what Article 267 of the Treaty on the Functioning of European Union said. Had the contracting parties to the withdrawal agreement intended that this power to refer would be a compulsion to refer, it would have used the same language. So we say the change in language to a discretion is significant, but in any event, we say that the position is very clear and there really isn't the slightest encouragement in the case law for the proposition that's being advanced, and so even if there were a power to refer, we submit it isn't necessary to exercise it. So those are my points on the reference issue.
And you say we should not, so there's no power to make a reference?
There's no power to make a reference. Is it in a nutshell?
And if there is, we shouldn't.
Yes, exactly.
Because it's I think that you would say that it wouldn't even meet the sulfate criteria.
Yes, it's absolutely clear.
And now it's a discretion rather than an obligation, so a fortiori,
precisely.
You say, anyway.
So those are my submissions on the reference issue, unless the court has any questions on that issue.
Anything further? Thank you very much.
I'm fond of the word mop-up. Can I just make another couple of points in relation to questions that arose during my oral submissions earlier? So, my Lord Sales asked about the risk covered in inverted commas in De Kuiper.
Oh, yes.
We think that's just a reference to the court's own language in paragraph 24.
That's what I wondered, yeah.
The second question was about the reference to predominant in the case law. The only circumstances where we can find that is in the particular circumstance I mentioned, which is dealt with in Al Hashem, which is about that very limited category of benefits for job seekers. So it doesn't arise in the context of the social security coordination case law, certainly that's in the bundle. And then the third point, again, in relation to an observation made by my Lord Sales, is that the court said that it would be helpful to see examples of the court categorising benefits when there are rival benefits in contention. Could
yes.
I just note another couple of examples? I won't take the court
So
to them.
De Cooper is one of them.
Yes. In footnote 2 of our written case, we give another couple of examples. If the court were to want to see further examples of how the court has done it on particular facts, there is the case of CW, which is at page 18. CW. These are both in footnote 22 of our case. So CW.
Sorry, 22.
22. So CW is a case where there's a contest between sickness, invalidity, and unemployment benefit. And the other case that we mention is Peterson. That's to be found at 2321. And there the contest is between invalidity or unemployment benefit. So we say they're just further examples of the court categorising a benefit, and they're further examples of the point that the court has to do so that it knows which rules to apply in Title 3. So those are my mop-up points. Could I just turn my back again for a moment?
Yes, of course.
Unless I can assist with anything else, those are our submissions.
Very grateful, Ms Smith. Thank you very much.
It's always quite helpful.
30 minutes, Mr. Delamere.
Oh, I thought I might squeeze the extra.
No.
No, sorry. Just to be clear from the beginning, my lord.
That's why I make it clear.
It's always helpful to identify right at the outset the points that you've made that your opponent hasn't engaged with. There hasn't been any substantive engagement with all the points of similarity between CTC and the child element. All of that is explained away basically on the common factor calculation. So it's common ground that all of those striking characteristics are the same. Secondly, there hasn't been any engagement with the language of and the responsive nature of the SNCB category. The SNCB category was designed to respond to Newton and Hughes. It was designed to respond to what in the language of the court is a dual or hybrid benefit. That's meeting a non-coordinated risk like poverty, along with just one of the coordinated risks, such as sickness or family benefits. There's no attempt to dispute the fact that Newton and Hughes led to the creation of the SNCB category, and there's no attempt to dispute the language of the SNCB category in Article 70, the language of supplementary or ancillary addressing of risks, but also related to poverty, being apt to describe the very essence of the CTC and CE benefit. And thirdly, there has been no attempt to explain on the plane of policy or principle why there should be the hole in the donut of referability. The answer is the text is the text, the timing is the timing, that's that. And there's no attempt to explain why the hole in uniform protection for a substantive right that is intended to be continuous arises. So let's start with the substantive issues. And let's start by asking why you even ever need to talk about the language of severance at all. Why is it that it crops up so infrequently in the case law of the CJEU? And in my submission, it depends upon the perspective with which you start as to whether or not you ever talk about severance. If you adopt the approach of the CJEU in a case like Lacheb, and you simply look at the allowance in dispute, whatever it may be, then there is no use for or need to couch your analysis in the language of severance if you don't extend your analysis to the wider benefit. It's only in a case such as the DLA cases, where the framing of the case is already set by reference to the wider benefit, that you need to use the language of severance. And of course, in the DLA cases, that was the framing, because it was the listing of the DLA benefit as a whole that was under attack, which then raised the question, could the mobility component be severed so as to meet the special test at Lim 1? And could the overall listing of DLA be unpacked so as to be in the long form, as my Lord Sales put it, to which the severance test of the blue pencil is then applied? So whether or not you look at the cases in terms of simply the benefit at issue or severance is a function of perspective, as I suggested right at the beginning. Now, I don't think that this debate, which is really about the substance of what remains in universal credit, is going to be answered by the use of emotive language. I don't think it's helpful to describe it as reaching in or plucking out, which is how my learned friend may put it, or as we might put it in the same sort of colourful language the other way, blending in and mixing up. The question, surely, is one of substance. That's what the objective test requires. And the question has to be logically set by reference to CTC, because of its very, very close relationship with CE. The relevant question is, has anything of substance changed such that that thing that formerly was coordinated is no longer coordinated? Now, in this connection, my learned friend made what I think is an extremely important concession. She conceded in terms that if it had been a feature of CTC that its award was predicated on a prior award of some other benefit. It was a question my Lord Richards put to her in terms, would that stop it from being a coordinated benefit? And her answer was no, it would not. So logically, if CTC had been designed in such a way as to say only those who receive, let's say, a conventional social assistance benefit like income support, which everyone accepts is not itself a coordinated benefit, and CTC was only available to those who received income support or working tax credit, that would not detract from the analysis. And she was quite right to make that concession, because the question would be, look at the conditions for the receipt of this particular benefit, go through them in terms, this one's not a condition, Article 3 condition, receipt of this prior benefit, not an Article 3 condition. But there is a condition that says you have to have a child in order to receive this extra amount of money. So one of the 3 or 4 or 5 conditions is an Article 3 risk. That turns the benefit into a coordinated benefit. Now, once that concession is made, with respect, first of all, her attempts to distinguish Commission and Parliament fall away. She distinguished Commission and Parliament on the basis that the two components were wholly separate. And she said, because they can be awarded one without the other, that puts us in a very different circumstance. But it can't be that the conditionality of the child element upon the standard allowance is the distinguishing factor. Once it's accepted, it wouldn't have been a material factor in benefit design. So the only thing we're left with, and what I submit is now clearly the heart of this case, is the effective acceptance of or advancement of the calculation factor arguments at the heart of the analysis of the upper tribunal judge. That's where this case actually boils down to. And it's important to identify the formalism of that argument. Why? Because in substance what you had before their consolidation into universal credit is 6 benefits predicated on poverty and predicated upon the awards of certain sums of money if you met poverty outright as a condition for income support or working tax credit, or if you met poverty plus some other condition, such as disability, or in the case of CTC, child raising responsibilities. So you have 6 benefits, each of which have as a uniform feature the requirement to be providing a subsistence income. You have some generalised benefits that provide simply for the threshold income, let's say £1,000 a month. And then you have some other benefits, like CTC, that say you'll get £250 a month if you are poor and if you have child-rearing responsibility. What is the difference between those 6 benefits in those six different forms, or as aggregated into a benefit that says, if you show that you meet the common test of poverty, you get £1,000. And if you also show that you have child-raising responsibility, you get £250 per child up to the cap of the number of children in question, or you get £500 for your disability. There is no substantive difference. And the answer isn't in calculation factors or anything of that kind. Why? Because child tax credit was means tested in exactly the same way as income support, as universal credit is income tested. Indeed, there were passport provisions, we can provide the details if it's helpful, that say if you pass the means tests for the other benefits, you don't need to retake the CTC. And it was coordinated as a matter of income. And what happened was that certain benefits were counted as income towards child tax credit, and certain forms of benefit were not. All of which was designed, in effect, for the benefits to operate in tandem so as to provide a combined income for people who were poor and people who had children. So nothing, with respect, has changed in that respect. And to describe the Section 10 allowance as a mere calculation factor in those circumstances is, with respect, a triumph of form over substance. Because what you receive and the basis on which you receive it is substantively unchanged. It is received precisely because you are poor. Indeed, my learned friend put her objection to our analysis in this way. She said of the Section 10 element, no discrete child amount can be claimed. It's simply a means of determining the appropriate payment to a household in order to meet the needs of that household with respect to children. And that analysis in relation to Section 10 is precisely the analysis that was advanced in relation to child tax credit. It's exactly the same substantive need being met in exactly the same way. You identify people that are poor, and you identify the incremental amount they need to receive because of the number of children they have and the extra needs that those children generate for their conditions of poverty. So all of this argument about calculation factors and matters of that kind really obscure the substance of what's going on. At the end of the day, as my lady put to my learned friend, really, this is a question of what extra amounts are counted. And that was always the analysis in relation to child tax credit. There is no material difficulty in working out the additional sums in question. The fact that they are tapered or means tested is not a material change. And this is critical, the fact that the coordinating rules of the regulation may then apply to them with certain consequences, such as the disapplication of residence requirements, is not a feature that can be prayed in aid to defend or justify the present circumstance. It's just the operation of the law. If the operation of the law requires a rule of residence to be waived, so be it. If you have designed your system in such a way that doesn't cater for it, then you must comply with the law and amend your system accordingly. You can't pray in aid an assumption you've made in your benefit design that turns out to be wrong. And I would suggest, in any event, the arguments in that respect are also overstated. It is not unusual for the Secretary of State. In context, you might find it to be surprising to invoke the regulation in order to deny competence and to deny a benefit being paid, which otherwise looks like it should be in payment. And we've added to the supplementary bundles a very useful example of that. It's a case called Harrington, not to be confused with the case of Carrington. Harrington was a case about disability living allowance care component, which...
where's the reference?
It's in the supplementary bundle of authority.
Yes, I've got that page.
Tab 3, page 19 of that supplementary bundle.
Do you want us to go to it?
Why not? It's a case with...
Bear with us then while we find it.
It's a It's a case with horrendously complicated facts.
I see you were there for the Air Centre.
I was indeed, and I'm happy to say that the Air Centre's arguments were accepted by the Court of Appeal, notwithstanding them saying repeatedly it was the most difficult case they've ever encountered. What it was a case where there were 3 candidate people or insured persons under the Article 11 test.
And just before we plunge into the detail of it, you're citing this for what proposition?
For the proposition that disability living allowance, which looked like it should be paid because a habitual residence test was met by the relevant person, it was concerned a mother who lived in the United Kingdom with her disabled child, and she was entitled to a version of disability living allowance in consequence. It looked like it should be in payment to her because she resided in the UK. The UK was saying, we're not the competent state. So even though the legislation says you should be paid, because of the operation of the regulation, in fact, Belgium is the competent state.
So you're telling us about the case, but what's the proposition?
The proposition is simply that routinely the DWP raises arguments based upon the regulation and the regulation alone to say that it's not the competent state.
So your point is that the DWP here was relying on the coordination to override the wording of its own regulation?
Absolutely. In relation to a case which looked a lot like social assistance because it had an HRT.
This is about disability living allowance.
Disability living allowance mobility component.
Right.
And it looked like...
How does that help us on this case?
Because what's said by my learned friend is, look at the catastrophic consequences.
Oh, I see.
And one of the
going to the construction.
Yes, it doesn't go to construction. But
it just goes to the catastrophic consequences.
It shows there are no catastrophic consequences because the department is perfectly happy to raise the regulation and the effect that it's no longer the competent state when it suits it to do so. And here they were arguing we're not competent. Why? Because Miss Harrington's father lived in Belgium and worked in Belgium, so Belgium is the competent state for the purposes of this sickness benefit.
But this isn't a coordinated... I mean, there's no question of it. It was, wasn't it? Yes.
It was a coordinated...
I mean, that's common ground.
Yes, but the question that arose in the case was which state is the competent state? And it was decided that the UK was the competent state, and because it was the competent state, the benefit was paid. The only reason I point to it is it shows that the sort of sky will fall consequences are difficult to reconcile with the department's own free invocation of this regulation when it suits them to seek to avoid a payment that appears on the face of domestic legislation to be fully payable. So, really the argument boils down to the characterisation of the child element. And it really boils down to a question of whether or not you accept it is in substance, really much the same as the old CTC allowance, that for all the pointing to supposed difficulties in isolating a particular element, it is all, at the end of the day, the same old maths to identify the same sort of sum, which sum is triggered, and triggered only by the satisfaction of an Article 3 risk. And that's our analysis, and that's why we say, with respect, the child allowance, or child element under Section 10, differs from the household calculations my learned friend introduced in presenting a picture of complication and difficulty of analysis. Those factors, do you remember the 55% factor and whether or not you took that into account and how single parents or working parents with care responsibilities work in, those factors are of entirely different character because they go to, effectively, how you operate a tapering provision. And those tapering provisions operate not just in relation to the Section 10 element, they operate across the board to all of the income receivable under the basic allowance, etc. They don't generate any form of entitlement at all. There's no sum of money that is generated axiomatically and automatically as a sum that you're entitled to. They're merely elements in calculation in relation to what comes out at the other end. And for that reason, you may think it's a fine distinction, but we say that's different in substance, which is why, as we've explained in our case, we've never challenged those elements. And it's why, therefore, the conventional test of responsibility under Regulation 4 applies unvarnished or without modification by the regulation. So there we have it.
In the household element.
Indeed, yeah. So I should say a few words about the case law. Herx. This really is front and centre of my learned friend's case as it was below. But what she perhaps failed to engage with is that we have accepted that the Herx analysis is alive and well, it's good law. The question is, what benefits do you apply the Herx analysis to? And we say the Herx analysis is applied to the standard allowance. Applying a Herx analysis to the standard allowance tells you that the standard allowance, well, it's not social assistance in the sense of being discretionary, but it's not a coordinated benefit because, just like the Minimax, it doesn't turn upon or isn't triggered by the satisfaction of any Article 3 risks. But if the relevant analysis is standard allowance gets its own analysis and the Section 10 allowance gets its own analysis, that doesn't take you any further.
And I mean, you'd accept the same, would you, for the housing amount?
Indeed.
Yes. So that too, that's in the same category as the standard allowance.
Well, each allowance or each discrete and severable component will receive its own analysis. And all we're concerned with is the analysis that pertains to the Section 10 analysis.
Yeah,
so Herx really is only part of the story. What is striking is that my learned friend doesn't really seriously attempt to engage with either Hughes or Newton. And Hughes or Newton, their significance lies in the fact that they say where there is one risk in play that is not a coordinated risk, so like poverty in the Minimax debate or like housing, and another risk that is in play because it's an Article 3 risk, then the Article 3 risk wins every time. And even though it has a dual character, that's the wording used in Hughes at 19 and in the case law that follows, it is still nevertheless a coordinated benefit. And that may be the case even if the child element is subordinate to, or ancillary to, or supplementary to use the language of Article 70, the overall objective of meeting poverty. That's the essential difference between a case where you have a contest between a non-coordinated risk and a coordinated risk. When you have a contest of that kind, the coordinated risk wins.
And the result of that is what in this case?
Well, the result of that in this case is that the Section 10 element does indeed address poverty, but it also addresses family risks, child responsibility.
You treat that as a separate benefit.
You treat it as a separate benefit unless...
So universal credit is a collection of separate benefits.
In substance, you teach each allowance on its basis.
Yes.
But does your Hughes and Newton point, are you relying on that when you're looking at universal credit taken as a whole to say, well, universal credit has got quite a large component which is poverty alleviation, but never mind because it also addresses a family risk and so is a coordinated benefit taken as a whole? Or are you relying on Hughes and Newton to say once you've taken out, or to use a neutral phrase, the child element, that child element in itself could be seen as both alleviating poverty and meeting a risk covered by 3(1)J, and in those circumstances, the risk wins out.
The latter, my lady.
The latter.
The latter. Exactly the latter. We don't attempt some form of universal classification of the entirety of universal credit. That's not too many universals. Because it wouldn't work as much as anything else, because different elements do in fact respond to different risks. There are elements that appear to respond to disability, which is a different coordinated risk. So Hughes and the creation of the SNCB category is in our submission fatal to the Secretary of State's analysis. And as a point of information, it's wrong to say that there wasn't any discussion about whether or not universal credit needed to be listed or elements of it needed to be listed as SNCBs. If it's helpful, we can provide the Social Security, what's it called? The committee report for the creation of universal credit that discussed this very issue. It's a statutory committee set up to review the creation of benefits. And it raised this very issue as being one that raised policy issues. So it's not as if it wasn't thought about at the time. So that's Hughes and Newton. De Kuyper, we think, is an entirely neutral case because the only issue in De Kuyper was a simple issue of classification. Was there any Article 3 risk in play at all? It wasn't a Hughes-style hybrid benefit addressing poverty and an Article 3 risk. The contest was between a coordinated benefit and an uncoordinated benefit, and it was decided it was a coordinated benefit. So we don't think the Kuiper takes matters very much further. Commission in UK, all we ever relied upon for Commission in UK was to show that child tax credit is a coordinated family benefit, notwithstanding its sharing of pretty much every single feature of the child element. And the fact that the UK conceded that, but the CJEU nevertheless recited its conclusion, might go to whether it's obiter or not, but so what? We're all agreed child tax credit was a coordinated benefit. Commission and Parliament and Bartlett, they are severance cases, but as I explained to begin with, they're severance cases that arose only because the court needed to approach the issue from the perspective of severance, because the benefit of DLA as a whole was at large, because it was the benefit of DLA as a whole that was listed in Article 2. So can I, with my 3 or 4 minutes remaining, pass the reference issues? First of all, Section 12.8. This, in our submission, is a total red herring. It's a red herring for a couple of reasons. The first reason it's a red herring is because everyone's accepted that if the withdrawal agreement requires, on the proper construction of Article 158, a particular conclusion, Section 12.8 must give way to it. So that's the first reason it's a red herring. The second reason it's a red herring...
Sorry, why does Section 12.8 give way to that? If Section 12.8, on its true construction, it says you look at matters at the time of the decision, because the withdrawal agreement wasn't in place at that time. Why does the withdrawal agreement override that?
The question of referability that arises under Article 158 must receive a uniform EU answer. It can't be the case that whatever the particular domestic provision is that's in place in a particular forum, a different provision in judicial review, let's say, to the Social Security Act, can dictate procedural powers. It is about procedural powers, and that feeds into my second point.
Well, before you move on, it must depend on the nature of the issue arising in the domestic proceedings,
and
whether that falls within the ambit of Article 158.
Indeed it does, but that leads into my second point, which is that
I don't understand why you say it has to give way to 158. The prior question is, what is the nature of the issue in domestic law?
Well, I accept that, my Lord, and then whether or not that issue is characterised as being one as a question of interpretation for the purposes of Article 158. But the second point, and it is a related point, is this. The substantive law throughout is unchanged. The substantive law is Regulation 883, and there's never been any material change to Regulation 883. What we're talking about is a change in, to use the language of Miller, conduit pipes for the same Regulation 883 to apply throughout. So there hasn't been any change in the substantive law, and a change in the power of reference of this court. That's what we're arguing about.
But the character of the law may be changed. It may be that it was, at the initial stage, assimilated EU law, and at the second stage, that it was law applicable pursuant to the withdrawal agreement and its implementation.
The characterisation of Regulation 883 may indeed change, as my Lord has put to me, but the underlying substantive obligation...
The content of the rules may be the same.
But that's the point.
Doesn't mean they're the same rule.
What Section 12.8 is directed at is a change in the content of the rules. And it's saying, if it says anything beyond facts, it's saying you can't prenade that the content of the rules changes later to say that that content of rules should apply to a dispute at a time that that content didn't apply. We're not seeking to do that. We're seeking to rely upon the same Regulation 883. And as my Lord Sales and my Lady Rose explained in their opinion in Lipton, changes in procedure of that nature take effect immediately. So, for instance, to give a more recondite domestic example, suppose the threshold conditions for permission to appeal from the upper tribunal to the Court of Appeal were to be changed after a dispute had started in the first-tier tribunal, or to suppose that your rights of appeal beyond a certain stage were to be removed. Section 12.8 wouldn't have anything to do with that whatsoever. And that, in our submission, is the answer to the point based upon Section 12.8. The objections of substance we accept are the ones based upon the wording of Article 158. And as to the first objection, the objection of the language commenced within, we say that is plainly a long stop provision. If you apply the kind of purposive construction this court applied in Skykick, and we refer you to the quotes from that judgment in paragraph 158 of our written case, page 134, the donut hole seems difficult to explain. And I would also point out that the language of Article 158 needs to be read in all of its different versions. The French version, for instance, instead of the word within, uses the word dans un délai, which means effectively by a deadline of. And that rather makes our point that what it's directed at is identifying a long stop.
Have you got the French text?
We haven't.
Well, please could it be supplied?
We can supply that in any other language version of that particular article.
Well, but the point about the language was that Ms Smith was making was a distinction between the provision that was in issue in Skykick and the provision that's in issue here. So if you're providing us with the language for one, then might be useful to see
We'll provide
what the language was of the article that was...
Article 67, happily. It is, of course, important to appreciate the very different context of the provision in Article 67. Article 67 is in Part 3, which are the transitional rules that apply in relation to things done before Brexit that have consequences afterwards. So, for instance, about goods placed on the market.
Yes, but if you're relying on a different language version, then we need to see whether,
yes,
if they used the same language in Article 67 as in Article 158 in French, then that would be...
How many authoritative texts are there of the withdrawal agreement? In how many languages?
One for every official language.
Well, I don't see why you confine yourself to one language in that case. I mean, up till now, this debate has proceeded on the basis of the English language.
My Lord is very cruel.
In reply, you're seeking... I'm sorry, I'm speaking.
I'm sorry.
In reply, you're seeking to introduce one of the new languages. For my part, it seems to be very late in the day to be introducing a different language version. But I don't at the moment understand why we don't have a smorgasbord of languages, if that's what you're going to do.
My Lord, the very fact that there are different languages of the official versions is one of the reasons behind the Silfit philosophy.
We've got the English language version, and that's the way in which this case has proceeded up till now.
Silfit seems an unlikely candidate to govern the discretion in circumstances where we're not bound to make a reference in any circumstances.
It's not that it governs discretion, my Lord. It's the point about Silfit is that one of the reasons why the CJEU may be better equipped to answer a question of interpretation that arises is that the CJEU is better placed to identify the true meaning of the text from all of the official languages, given that it works in all of the official languages, and given its judges are fluent in all of the official languages.
Well, as my Lord says, it's a bit late in the day, but we'll look at the French text, but we'd like to see the French text of both provisions, please.
Understood.
Thank you very much.
Unless there's anything else I can assist with further.
Ms Smith, is there anything you want to say about Harrington?
My Lord, no, we say that's not a helpful point, but thank you for the opportunity.
Thank you. Well, we're very grateful to all counsel and those sitting behind them. Grateful to counsel for leading us through these labyrinths for the over the last 2 days. And we're also very grateful to those sitting behind you for the preparation of the case. It's a very substantial amount of material, and we're very grateful. We will take time to consider our judgment, and the court